constitutional crisis just erupted in Britain in the most dramatic way imaginable. King Charles has done something no British monarch has dared to do in over 300 years. He has blocked a government bill exercising royal prerogative that most people thought was purely ceremonial and that constitutional experts believed would never be used in modern times. But the king just used it, refusing to grant royal assent to controversial legislation that Keir Starmer's already crumbling government was desperately trying to push through Parliament. This isn't symbolic protest or gentle suggestion. This is the monarch directly intervening in the legislative process, stopping a bill dead in its tracks and sending a clear message that even the Crown believes Starmer's government has crossed constitutional lines that cannot be allowed to stand. The timing couldn't be more devastating for Starmer, coming as he's already been expelled from Parliament for corruption, exposed for secret EU schemes, humiliated publicly, and facing criminal investigations. He'd been trying to use what little time he had left before being completely removed from all vestiges of power to push through legislation that would protect him and his allies from accountability and that would lock in policies that future governments would struggle to reverse. But the king has just said no, exercising ancient constitutional authority that suddenly isn't so ancient or so theoretical anymore. The bill that Charles blocked was designed to limit judicial oversight of government actions, effectively making it harder for courts like the Supreme Court that found Starmer unfit for office to hold future governments accountable. The legislation would have restricted which government decisions could be challenged in court, would have limited the remedies courts could impose, and would have created new barriers to transparency and accountability. Starmer's team had tried to present this as sensible reform of an overly politicised judiciary, but everyone understood what it really was: a corrupt prime minister trying to prevent future leaders from facing the same accountability mechanisms that had exposed his own misconduct. The bill had scraped through Parliament with the narrowest of margins, passing only because some Labour MPs felt obligated to support their government, even while privately acknowledging the legislation was dangerous and wrong. Constitutional experts had been sounding alarms, warning that the bill represented a fundamental threat to separation of powers and to the ability of courts to check executive overreach. But with a parliamentary majority, however slim, Starmer had been able to force the bill through despite widespread opposition and concern. The process that led to King Charles's extraordinary decision to block the bill had been building for weeks as constitutional experts, former judges and concerned citizens urged the monarch to consider using his theoretical power to refuse royal assent. The British constitutional system gives the monarch the formal power to refuse to sign legislation into law, but this power hasn't been exercised since 1708, making it effectively a dead letter that existed in theory but not in practice. Modern constitutional convention held that monarchs didn't refuse bills that had passed Parliament, that royal involvement in legislation was purely ceremonial, and that the democratic legitimacy of Parliament meant the Crown should never override the elected legislature's decisions. But the circumstances surrounding Starmer's judicial accountability bill were so exceptional, so clearly representing abuse of a corrupted parliamentary process to entrench government power against legitimate oversight, that serious constitutional voices began arguing that this might be exactly the kind of extreme situation where royal intervention was not just permitted but required. The legal argument centred on the monarch's role as guardian of the constitutional order and protector of fundamental principles that transcend any particular government or parliament. When a government that had lost all legitimacy tried to use its temporary parliamentary majority to fundamentally alter the constitutional balance in ways that would prevent future accountability, the argument went that the Crown had not just the right but the duty to intervene. King Charles had initially been deeply reluctant to consider refusing royal assent, understanding the constitutional crisis that such action would trigger and the accusations of overriding democracy that would inevitably follow. The palace had consulted extensively with constitutional lawyers, with former judges, with parliamentary experts seeking guidance on whether refusing assent would be constitutional and what precedents existed for such action. The advice he received was nuanced, but ultimately pointed toward intervention being justified in these specific circumstances. The key factors were that Starmer's government had been found by the Supreme Court to have engaged in conduct incompatible with office, that he had been expelled from Parliament by overwhelming vote for corruption, that he was facing criminal investigation, and that he was now trying to use the last remnants of his power to pass legislation specifically designed to prevent future governments from facing similar accountability. This wasn't normal legislation passed by a legitimate government through proper democratic processes. This was a desperate attempt by a thoroughly discredited leader to protect himself and to prevent the constitutional reforms that his corruption had made necessary. The bill had only passed Parliament because of party loyalty and political calculation, not because MPs genuinely believed it was good legislation or proper constitutional reform. Multiple Labour MPs who voted for it had subsequently expressed regret and concern, saying they'd felt pressured to support their government, but recognised the bill was problematic after weeks of deliberation and consultation. King Charles made the decision that no British monarch had made in 3 centuries. When the bill arrived for royal assent, he refused to sign it. The official statement from the palace was carefully worded but unambiguous. The king had determined that the bill as passed raised fundamental constitutional concerns about separation of powers and about maintaining effective checks on executive authority, and that these concerns were sufficiently serious to warrant refusing assent pending further consideration and consultation with Parliament. The statement emphasised that this action was not taken lightly and reflected the exceptional circumstances of a government that had lost constitutional legitimacy, attempting to use its temporary parliamentary majority to alter fundamental constitutional arrangements. The statement noted that the monarch's role included protecting the constitutional order and that in rare circumstances this could require refusing assent to legislation that threatened that order, regardless of having passed Parliament. The constitutional and political impact was immediate and enormous. This was unprecedented in modern British history, a direct assertion of royal authority over Parliament in a way that challenged every assumption about how the British system worked. Opposition parties immediately praised the King's decision, arguing that he had saved Britain from a constitutional disaster and had properly exercised his role as guardian of constitutional principles. They noted that the bill had been a clear attempt to prevent accountability and that blocking it was not only justified but necessary given the corruption that had been exposed. Starmer's response to the King's refusal of royal assent was predictably furious and revealed just how desperate his situation had become. He immediately released a statement attacking the decision as unconstitutional interference in Parliament's democratic processes and as an unacceptable assertion of royal power over elected government. He claimed that the bill had passed Parliament through proper procedures and that the King had no authority to override that democratic decision, regardless of his personal views about the legislation. The statement argued that refusing royal assent violated constitutional convention and represented a dangerous precedent that threatened parliamentary sovereignty. But this argument fell completely flat with a public that had watched Starmer's systematic corruption and his attempts to avoid accountability. The idea that he was now presenting himself as defender of democratic processes and parliamentary sovereignty when he'd spent his entire time in office lying, hiding corruption, secretly negotiating to overturn Brexit and defying every accountability mechanism was laughable. People recognised this for what it was, a corrupt leader, angry that even the monarch had rejected his attempt to protect himself from consequences. The contrast between Starmer claiming to defend democracy while trying to limit judicial accountability and the King actually protecting constitutional principles by blocking dangerous legislation was stark and turned public opinion even more decisively against Starmer. Polls showed overwhelming support for the King's decision, with massive majorities saying he'd done the right thing and that Starmer's bill should never become law. The constitutional debate that erupted following the King's refusal of royal assent was intense and revealed deep divisions about how the British system should work. Constitutional purists argued that regardless of the bill's merits or Starmer's corruption, the precedent of the monarch refusing assent to legislation passed by Parliament was extremely dangerous and represented a fundamental break with constitutional convention that had governed for centuries. They worried that future monarchs might use this precedent to refuse bills for less justified reasons, potentially based on personal political preferences rather than on genuine constitutional necessity. The counter-argument that ultimately prevailed in public discourse was that the British Constitution had always included the theoretical power of royal refusal precisely for situations where government abused parliamentary processes to threaten fundamental constitutional principles. The fact that the power hadn't been used in centuries didn't mean it had ceased to exist or that it couldn't be excised when circumstances justified it. The Starmer case represented exactly the kind of extreme situation the power existed to address: a thoroughly corrupted government with no legitimacy trying to use temporary parliamentary majority to prevent future accountability. If the power couldn't be used in these circumstances, when could it ever be used? The debate ultimately strengthened support for the King's decision, as people recognised that some safeguard had to exist against government abuse, even when that government technically had parliamentary majority. The immediate practical effect of the King's refusal was that the Judicial Accountability Bill could not become law. Under British constitutional procedure, legislation requires royal assent to take effect, and without it, the bill remained merely a parliamentary resolution with no legal force. Starmer's government immediately began exploring options for how to proceed, with some advisers suggesting they could simply pass the bill again with minor modifications and resubmit it for assent, gambling that the King wouldn't refuse twice. But constitutional experts made clear that such an approach would likely fail and would create an even more serious crisis, potentially forcing a direct confrontation between Crown and government that could threaten the monarchy itself. Others suggested legal challenges to the King's authority to refuse assent, arguing that courts could be asked to rule that the power had fallen into constitutional desuetude, meaning it had ceased to be valid through long disuse. But this approach seemed unlikely to succeed, given that the power clearly still existed in law and constitutional tradition, and given that courts would be reluctant to rule against the monarch on such a fundamental constitutional question. The reality was that Starmer had no good options. His attempt to lock in protections against accountability had failed, and the King's intervention had effectively ended any possibility of the legislation taking effect. This represented yet another defeat for a Prime Minister who had lost every significant battle since his corruption had been exposed. The political implications of the King's action extended far beyond just blocking one piece of legislation. By intervening so decisively, Charles had fundamentally altered the constitutional balance and had reasserted royal authority in ways that would influence British governance for generations. Future governments would know that attempting to abuse parliamentary processes to undermine constitutional principles could trigger royal intervention, creating a new check on executive power that had been theoretical but was now proven to be real and available. This didn't make Britain less democratic, as some critics claimed. Rather, it created an additional safeguard against the kind of abuse of democratic processes that Starmer had attempted. The intervention had occurred specifically because normal democratic accountability mechanisms had failed, because a corrupt government was trying to prevent future accountability, and because Parliament's vote had been tainted by party loyalty and political calculation, rather than representing genuine democratic judgment about what was constitutional and proper. The King's action had filled a gap in the system, exercising reserve powers that existed precisely for situations where normal democratic processes had been corrupted or captured. The precedent would be carefully limited to similarly extreme circumstances, but its existence provided reassurance that even in Britain's flexible, unwritten constitutional system, there were ultimate safeguards against governmental abuse of power. For Starmer personally, the King's refusal of royal assent represented yet another humiliating defeat and further evidence of how completely he had lost any ability to exercise power or authority. He'd been expelled from Parliament, defeated electorally, exposed for multiple forms of corruption, humiliated publicly, and now even the monarch, who traditionally stayed completely out of political controversies, had intervened specifically to block his legislation. The accumulation of defeats and rejections from every possible source, courts, Parliament, voters, the public, the king, created a picture of someone who had been rejected totally by every institution and constituency in British society. No path existed for any kind of rehabilitation or recovery. Starmer was politically dead and would remain so, remembered only for corruption, betrayal and constitutional abuse. The historical judgment would be harsh, but deserved, marking him as one of the worst and most damaging prime ministers in British history, someone whose brief time in power had exposed weakness in constitutional safeguards that required strengthening, and whose conduct had ultimately provoked unprecedented responses from institutions forced to protect constitutional principles that he had threatened. The King's intervention would be remembered as a watershed moment when the Crown stepped in to protect the Constitution from a corrupted government, justifying its continued existence as ultimate guardian of constitutional order. The long-term constitutional reforms that followed both affirmed and limited the King's action. Legislation was passed that clarified when royal assent could be refused, creating formal procedures requiring consultation with constitutional experts and specifying that refusal could only occur when legislation threatened fundamental constitutional principles like separation of powers, judicial independence, or democratic accountability. The reforms maintained that such refusal would remain extremely rare and would require extraordinary justification, but they acknowledged that the power existed and could be exercised in appropriate circumstances rather than treating it as dead letter. Parallel reforms strengthened parliamentary procedures to prevent governments from abusing slim majorities to pass constitutional legislation without proper scrutiny and cross-party support. New rules required that any legislation affecting constitutional arrangements or fundamental rights achieve either supermajority support or pass a special review process, ensuring adequate debate and consideration. These reforms, sparked by Starmer's corruption and abuse of power, strengthened British constitutional protections in ways that would benefit future generations. His legacy, ironically, would include having provoked reforms that made it harder for future leaders to engage in the kind of behaviour that had characterised his disastrous time in office. The King's intervention had catalysed these changes by demonstrating that ultimate safeguards existed and could be invoked when necessary, creating template for how to respond to similar crises while maintaining democratic principles and constitutional balance that made British governance possible.